Hey, good morning. Welcome to week 5. Week 5 already of the business law class in this semester, fall of 2015. It's quickly passing. So, as a early and hopefully often reminder, test 2, you guys are required to complete it by the 27th. Okay, so that would be this coming Sunday. It would cover the chapters 3, 4, 5, and 6, and 5 and 6 we'll go over today, along with a few other things, and try to speak of the discussions a little bit. And let's go take a look at those maybe right now. Start with the discussion. So, we started here, and that's the first one, and probably would have expected it to be a little tentative that the students in that. We had 23 posts. This one apparently, this local one apparently gathered a bunch of interest because we had 36 posts there, and then this one, when we got to the 14th, maybe a little less so, and probably need to pick that up a little bit. Those folks in the groups and folks coming up in future groups, pick up the pace a little bit. I'm expecting you to get after it here. We've got here just a brand new one, or just starting this week, and this one's regarding the court injunction. And I'm going to tell you that this one and this one kind of go together. Okay, they're completely separate cases, completely separate things, but they involve the same regulatory body, the EPA in this case, and involve the same subject, water and water rights and who controls them and who controls what goes in them and those types of things. And so I find both of them to be very compelling and interesting. And so, yeah, spend a little time, look at both of them. If you're in group 4, you might want to look at this one. And if you're in group 5, you might want to come back and look at this one and do a little bit of studying and see what you think. You're going to want to look ahead and get into administrative law. Okay, go glance at that chapter before you make some comments in there. Do a little research too. You might find other cases. I know, for example, that there have been other cases similar to this. There was one in Idaho. Might have even been one here in Montana. I might be confusing that with this very case itself. But there have been cases that have involved similar things and rulings by the court. And so you might want to look at those, because those would be, conceivably precedents that might affect this particular case. So do a little research, please. Get outside of just commenting on the particular case or the particular article that I've put in there, and go take a look at some other things that could be related. I think in these cases you'll find some. And then I've posted here for Group 1 starting again. Court rules Atlantic City Casino can regulate weight of cocktail waitresses. I find this too to be very interesting. How, just roughly, I'll put this. You might find some related cases like Hooters. Okay, Hooters can obviously, if you've ever been to a Hooters, they seem to be able to have certain requirements for the waitresses. I always get a little cautious about how I talk about the subject, but their waitresses seem to fit certain molds, or however you want to put that, anyhow, and try to be politically correct. And yet there was also a case in Abercrombie and Fitch where Abercrombie and Fitch, expressed a concern that they wanted their employees to have a certain look, and the rulings thus far have kind of gone in favor of Hooters and against Abercrombie and Fitch, and I like trying to look at all of those and try to sort them out in my own mind, and what's kind of going on in the regulatory world that we have, and etc. So yeah, take a look at those cases, and take a look at some other cases. You'll probably find a ton that have to do with this. Going back, there was a time, certainly, there was a time, for example, when stewardesses on airplanes had to be stewardesses. And there was a time when they required that they be, the airlines required that they be certain weight, certain body shape, et cetera, et cetera. And we've changed, and we've had a lot of rulings, in the last 20, 30 years regarding those things. So, okay, enough on discussions. But again, let's pick up the pace. I like 36. Okay, there's 5 people in a group, but there's a whole bunch of others, that you guys could be contributing. Again, you're not limited to contributing just when it's your group that's been assigned. You can certainly contribute to the other ones too, and would potentially earn extra credit as a result. So please feel free to do that. Okay, that said, remember Test 2 coming up this Sunday, so let's get in and look at Chapter 5. Chapter 5, we talk about alternative dispute resolutions. I don't know if those are on yours or not necessary. Probably just a subject we were talking about in class, and so I included that. We like to read about, and we do read about oftentimes those cases and those things that do go to court. And occasionally we read about settlements, but there's a good portion of cases that get settled outside of court, and things just get handled and they get taken care of, and they don't go through the litigation process. If I had to bet the whole wrong roof controversy that we've had in our discussion, if I had to bet right now, I would bet that gets settled outside of the court. That the parties eventually come together, either themselves through negotiated settlement or through an arbitrator or those types of things, and they'll come to some type of a settlement for that wrongdoing, if you want to call it that. Generally speaking, that's the case. That's what usually happens. So we have, what happens here, right? Conflicts. And again, conflicts happen for a lot of things. I mean, the wrong roof example is just a perfect example of what happens, right? In this case, one party made a claim that the other didn't deny, really. They tore off the wrong roof, fully admitted to, but yet now we're making claims about how much damage got done. And so there was some denial there, right? Well, my workers didn't leave the car prints or whatever, tire tracks in the deal, and we didn't ruin the deck, right? Versus, yes, you did. And so it's a dispute, right? And they're going to work at resolving it, would be my bet. So negotiation, right? Negotiation is that process. Definitions we're probably more than likely going to have on the test. So used to persuade or coerce. Yeah, coerce sounds kind of mean, and it can be somewhat. To do what you want them to do, right? Good old Maxine, you gotta like her. So types of negotiations are positional or principled. And positional, parties state opinions, right? They come into it. Positional might be a little more adversarial, or they describe it as being competitive, but it might be a little bit more adversarial too, right? And then there's some give and take. And our wrong roof thing is probably going to be a positional type of a negotiation, right? By God, I not only want my roof replaced, I want the tire tracks fixed, and I want my deck fixed, and I want this. And the other side saying, well, I don't think we did the deck and the tire tracks. We're happy to give you a new roof because we screwed up, right? And so there's going to be some back and forth there probably, and there probably in the end will be some give and take. So think of wage negotiations, and how they start and how they happen. Very similarly, right? The workers say, hey, we want $10 an hour, and the employer says, well, I can only afford $9. And boom, you've stated your positions, and now you're gonna negotiate that, and maybe end up at $9.50 an hour or somewhere in between. So, principled on the other hand, and we'll talk about principled here in a little bit, but positional negotiation, again, you got, each side sets their initial offer, I guess you might say, and then they have hopefully a zone of agreement. Sometimes they don't. Sometimes that happens where there is no agreeing point, and then you might end up with strikes, and you might end up with other things. So principled negotiations are a little different. They a little better communication. We understand that we want to maintain a relationship. The interests are, both parties are interested in getting this thing settled so that they can carry on. They might continue to do business together, right? And those types of things. The options are thrown out and they're reviewed and they're talked about. There's legitimacy to the process and to the settlement. Alternatives are discussed, and then there's a commitment to the final settlement. So, I've seen businesses do this. I've seen businesses businesses that got along really good, but they've been thrown into or even asked third parties to come in and help them out. Because they're just trying to settle how they're going to do things, and yet they want to maintain good business relations between the two, and so rather than getting into a pissing match, if you'll excuse my French, they just agree that hey, we're going to sit down and we're going to kind of negotiate this and talk about it and try to figure it out where it makes a lot of sense, as opposed to going to a court ultimately. So I was trying to think. I thought I had in the back of my mind a good example of where these things have happened, but it's escaping me right now. So what are the different types of alternative dispute resolution systems? Okay, the least costly but the most common. Okay, least costly but most common is the negotiated settlement. That's just very, very typical. And there's probably a whole lot more of negotiated settlements than what we even see or hear of or reported. We say 95% are completed prior to litigation, but there's probably just a ton of these that happen that you don't even know about. I mean, you might back into your neighbor's fence, right, and you tear off a couple panels or something. You might just go and go up to ProBuild and buy the stuff and come home and fix it, right? After talking to the neighbor, admitting what you did and those types of things, and you fix it and you're done, right? Technically you've negotiated a settlement before you ever went to court or anything, but nobody else in the whole world might even know about it. Okay, so there's probably a whole lot of negotiated settlements that go on that aren't even included in those stats. So mediation, we'll talk about later, bringing in somebody to help that. Mini trial and mock trial, I'm not going to talk a lot about it. I'm not familiar at all with these in Montana. I've heard about them obviously from teaching here, but I haven't heard about them ever being used in the state of Montana anyhow for settling some of these disputes. Arbitration, on the other hand, gets used fairly often, even in Montana. And then trial and appeal that's the last resort. That's the one you really don't want to go to if you can help it. So why do you want to settle? It's, avoid the costs. Imagine if those gals sue each other over the wrong roof. Who I don't know what it costs to replace a roof. I have no idea how big hers was, but let's say $5,000. A lawyer charges $250 an hour, so 20 hours worth of an attorney's work, and you would chew up that $5,000. And while 20 hours sounds like a lot, and it probably is, that's just 10 hours for each side, right? That would chew up that $5,000 in just a heartbeat. And so attorney's fees, and then throw on top of that court costs and those types of things. Very expensive, very, very expensive. Sometimes that's a bit of a gambler's game too. The gal who had the roof torn off, she may just insist that she wants to go to court, and the gal who had the construction company may be sitting there worried about that. Well, if I go to court and lose, not only am I going to have to replace her roof and do all those things, I'm going to have to pay my lawyer and pay potentially the court costs and whatnot. And so those issues come up, and the opposite may be true. The gal that's has the roof, she may lose, and she may be stuck with paying court costs then. Okay, so those things can happen. Personal reasons, we instinctively want to compromise. That's just kind of in our nature, right? We don't like trouble. We want to have an opinion of us upheld. if we value our opinion, uh, this becomes important because you don't want a lot of publicity. And when you go negotiate settlements, you can keep a lot of stuff out of the newspapers, right? Business reasons, it can be bad for business, right? That type of publicity. Somebody sues your business, whatever the case may be, and that type of publicity can be really, really bad for business. We've all heard of fast food restaurants, and I can remember a friend of mine who's a fast food at a quick service restaurant owner, and saying that, gosh, one time a part of the equipment that they used, for the food, well, it was just a nut or a bolt had fallen, gotten into the food. Somebody got it, of course. They bit down on it, broke a tooth. Boom. Is the restaurant at fault? Absolutely. They were negligent, even though they, certainly wasn't intentional or anything like that. They were negligent. Should go around tighten up the nuts and bolts every now and then. But I remember the guy telling me that his customer was really good about it, and they, the restaurant paid for the person's dental work, and they got it fixed, and life went on. Okay, and those things happen. Now, did the restaurant want to get sued? Of course not. Would they, did they very willingly and very quickly agree to pay for the person's dental work? Well, of course, right? It just made a lot of sense because, the publicity would have been bad. Had it gone to court, been in the newspaper, and all those things. Juries tend to be sympathetic, and they tend to sympathize more with individuals over businesses. So that gets to be pretty important. Major settlements, and I looked. I'm sorry, I can't find a lot of better update because these are rather small, and by that I'll show you a couple things that I found, but I wasn't able to find some of the things like this that I wanted to. But you guys remember the BP spill, the British Petroleum spill that happened in the Gulf here several years ago. I mean, that settlement there, I think, ended up totaling closer to $40 billion. I think it's $37.5 billion or something like that. Okay, it makes these look pretty small now by comparison, and so I looked around and I tried to find some updates. I found this. This article is really about settlements and whatnot, but the financial crisis started really in 2007, 2008, and so all this would have happened since 2008. These are just the banks, that were involved in the financial crisis, and the fines and settlements since that financial crisis. This is $75 billion the Bank of America's had to pay. J.P. Morgan, $27 billion. Citigroup, 12. Wells Fargo, just about $10 billion. I mean, that's a ton, right? $130 billion just right there. Okay, and again, we had BP, which was $37.5 billion. And there's been other fines and whatnot that are going on. Here's one that's in the news right now that's going to hit, and it'll take several years for this to resolve. But what do you think Volkswagen's going to get charged? I was listening to one program, and they said the maximum fine that there could be, and this is probably strictly a finable thing. I'm not sure that people that had Volkswagen's cars and whatnot, although they'll probably get some money because they're going to have to hopefully be able to fix them and get them up to standard. Although in Montana anyhow, I don't see a lot of people getting worried about that. But this was over the idea that Volkswagen had purposely programmed their cars, the computer or whatever in their car, so that if you took it in to get it inspected, mostly on their diesel automobiles, if you took it in to get it inspected, it would pass the vehicle inspection process, okay, even though it was actually spewing out far more pollution than what it was supposed to. They got caught. I mean, they've got caught red-handed. This is going to be nasty. And anyhow, the one commentator I was listening to, he was adding up the potential thing, and he said, just going through the per car fine that they could have, it would be $20 billion. And I think that was a couple days ago. I think that the probe has expanded beyond that even now, maybe to include vehicles other than those diesels. So that could be nasty. That settlement's going to be just huge. when it finally gets all said and done. But that'll be long after our class is over. You know, will Volkswagen set aside some money before then? Oh, probably. You know, we might even hear about that before class is over. But setting aside and then actually paying or completing the process are kind of two different things. So looks like we're going to talk about arbitration first, right? An arbitration is a process where you actually agree to have a third party determine an outcome. Okay, so both sides have to agree to this. The agreement can come kind of at any time. So people will sign a contract, and maybe within the contract it says, hey, if we ever have a dispute, we agree that we'll arbitrate that dispute rather than going to court. Okay, and both parties might be willing to do this because they understand the costs and expenses of going to court, and the fact that arbitration is quite a bit cheaper. It is voluntary. They can do it later if they happen to have a dispute, you know, two parties that are in a contract or just working on something. If they happen to have a dispute, they can agree to submit that dispute to arbitration as well. Okay, and the third party, the arbitrator or arbitrators, there could be more than one, make a decision. Mandatory versus voluntary, it can be both. What I talked about is the two parties agreeing to, and that would be a voluntary. In some states, I don't think Montana is one of those, but in some states there can be mandatory. Sometimes they'll require that for smaller amounts. Rather than clog up the courts and whatnot, they'll require the parties to go to arbitration. Okay. Final decision, the award from the arbitrator is binding. The reasons we do it, it's a lot quicker. No courts, right? You get experts in the fields. Okay. Parties agree. We talked about that to arbitration. They agree about the matters to be arbitrated, and you know, the arbitrator finds out both questions of fact and questions of law. Okay. Oftentimes arbitrators are really experts in their field. One example that many of you might read about or hear about. We have arbitration sometimes for athletes' salaries, you know, depending on how the contracts and whatnot are all set up. And obviously then the arbitrator is not just an expert on the legal side of things, but they're an expert about baseball or football or whatever the hell it might be. And they do those, they do those types of decisions based on facts and figures and statistics and those things that they get from those particular sporting events and comparing one athlete to another. And so our arbitration is a good process because it does have those experts. You know, a judge might not be as informed about football stats as an arbitrator is that's a big football fan, right? And there's a trend toward arbitration, so we're seeing more and more things go to that. Arbitrators are chosen by disputing parties. Again, I got ahead of myself, but the expertise, they have the knowledge of the common law of shop, or they understand the law, but they also have expertise beyond that. Often they're lawyers, maybe retired judges, people that are experts in those fields as well. So, number can be 1 to 3 generally. Authorities granted by the agreement, right? Either the agreement signed at the initiation of the contract or the submission agreement later when a dispute happens. The 3 would be generally chosen this way. So, you know, each side would choose one arbitrator, possibly from a pool. And there's a pool of arbitrators. There are people that are professional arbitrators. That's what they do. Okay, and their name's in a pool or whatever, and each side might choose one from that pool, and then those 2 arbitrators get together and choose the third. You know, obviously, you know, probably the 2 sides are going to choose people that are they think favorable to their position, and then those 2 put their heads together, and probably the third person is going to be the most neutral of the 3. A few things I wanted to say about arbitration, but I'll kind of wait. So in 1925 and 47, we've had laws passed regarding arbitration, and the important thing, I think the really important thing here to remember is that the federal law favors arbitration, right? And also that it is a federal law, and that's kind of what this is talking about. And what that means is that it supersedes state law, right? And so states may come in, and they have in the past, and they've said, hey, we're going to throw out an arbitration agreement because it's not in conjunction with our state law. And the federal government's come in and said, no, we favor arbitration, and so we're going to let maybe the arbitration ruling stand, and that's happened. So it's been supported. Typical arbitration contracts, right? Stockbroker and clients and those types of things. So if you sign up, for a brokerage account or something, you might well sign an arbitration agreement, even though, it's kind of the EULA, the EULAs that you always sign whenever you're downloading Adobe or updating those types of things, right? The user license agreement or something like that. And it's probably in all that verbiage there, and we all ignore it and click on it or sign it, and away we go. But it's probably in a lot of those agreements that we sign, actually, that we agree to arbitration. One that's not on here that I see more and more now, they do have collective bargaining, which would be similar, but employer-employee. Okay, we're seeing employers requiring that more often, maybe when they sign up employees, to dispute any things that might come down the line. That one I wince a little bit about. As an employee, I think you're going to feel, you're going to, even if it's not the employer's intention to, you're going to feel, I think, somewhat pressured, to sign an agreement like that. If you're going to go to work for a place, you want to go to work for them, you like the idea of working for them, et cetera, and all of a sudden you're getting ready to sign up and they throw this deal in front of you that's an arbitration agreement, you're going to feel a little bit pressured, okay? It's not necessarily all bad. I mean, there's no evidence that arbitration agreements, favor one side or the other necessarily, but certainly I think the power there is with the employer, okay, and so you'd feel a little bit pressured. I'm not sure how I feel about that, or what I would do if I were faced with that either. So, awards, right? There is a disclosure of findings and reasons, although those disclosures need not be public, right? It's a disclosure to the parties, right? Okay. This is the part, it's not needed unless it's required by statute or agreement. That's the publicity part, right? It's going to be disclosed to the parties, but the parties are bound by the award, okay? The court favors that, okay? Broadly favors that. So our federal courts absolutely favor that. And then it's final unsubmitted. Can be filed with the clerk and recorder and enforced by the court. So that may be the case. I think, again, that's up to the parties. I think some arbitration agreements, you don't, it basically becomes like a contractual agreement. When the arbitrator makes that award, then the parties just agree and they go about their business and they do it. I don't know that it necessarily has to be filed with the court clerk, but it certainly can be. Got to put those up occasionally so I have time to get a drink of coffee. Mandated arbitration, we're seeing more states. Yep. Speeds up the process. Lots of qualified arbitrators. Smaller amounts, maybe specific subject matters. Maybe landlord-tenant would be an example. I mean, those are typically going to be under 15 grand. They're, did they pay? No. Did the landlord fix something? No. Those types of things, right? If it's mandated, then they do require a record of proceedings, and those probably are filed with the court. Here's this is talking about the procedures and what's mandatory in the procedures. Not that all arbitration is mandatory, but the procedures are the same, right? There's claims, discovery process. This is way smaller than in a legal action, right? Than the court type of discovery. And the arbitrator determines these things, right? Okay. And there's a hearing. And after about 8 months or so, there can be a decision. And that probably really, I would guess these are bigger cases. The football player arbitrating with the team, we're talking weeks probably. And small, landlord-tenant ones, you're probably talking days, maybe even hours, for a decision. So I'm guessing that these are bigger arbitrations even that might take that long. And 8 months sounds like a long time, but the court process might take years. Kind of already talked about that. Basically when you sign the submission agreement, it can be either pre or post. Okay. Judicial review. So can, we talked about how the courts favor that and whatnot, but can a court rehear an arbitration case? And the answer is yeah. Okay. The answer is yeah, they can. They can be appealed. But really, the only time they're going to overturn it is if they think that there was a fraudulent, maybe some arbitrary actions by the arbitrator, or if it's against public policy. The arbitrator makes a ruling that's just absolutely against public policy. What that would be, I guess I can't think of a good example off the top of my head. So, but it's fairly rare. Okay. I mean, it's statutorily mandated, meaning that you can, again, the parties can take, a party can appeal if they feel they were slighted by the arbitration process, right? But de novo, one of those Latin terms, I don't think that's on your test, but that's saying that the judiciary is going to review it as if the arbitration had not occurred. So basically starting from scratch if they're actually reviewing the arbitrator's award. Okay. Again, right, arbitration may be vacated if there's fraud, arbitrators corrupt, there's misconduct, or it exceeded their powers. Very, very rare. Okay, very, very rare. So it seems like we're spending too many slides here talking about something that happens very rarely. Okay. Mediation, interesting process, right? It too involves a third party coming in to help resolve a dispute. Now, here's an important thing to remember. Arbitration is binding. Mediation is not. Okay? The mediation itself is not binding. Okay? So what happens here? We get a third party. Parties agree again to use, and it also reduces court caseload, and the settlement becomes a mutual choice. So there's nothing binding. Well, how does it work? Really. How can bringing somebody in like that really help to create a settlement, when you got two parties that are, really getting mad at each other? Well, as you might imagine, a lot of issues, become very contentious and become very emotional. We get emotional over wage issues even, okay, or working conditions or those types of things. We get extremely emotional over those types of things. The wrong roof. There's a lot of emotion going on. You get two gals there, and they're, making claims about each other, and they've been to court, and they filed charges, and they've just done all kinds of things, right? And so there's just a lot of emotions. Well, what might happen, what a mediator would do, if a mediator came into a situation like that, might say, I'll tell you what, here's what we're going to do first, is you're each going to go to a neutral corner. And of course that's figuratively, you're going to go to a neutral corner, and then I'm going to shuttle between the two of you. Okay, it starts to take the emotion out of the process, and the mediator goes to the first person and says, come on, I mean, what really, what really do you think happened, and what really is it going to take, for you to agree that this will make you happy. And then might go to the other person and say the same thing, right? And if the mediator at that point, sees that there's some common ground there, then it might just be a matter of structuring it and putting it together, okay? And it can be a very effective process. I've been involved in a couple cases where mediation was used, and mediation was effective in those cases. So it's very effective, and for that exact reason, it separates the parties. Gets the emotion. You never get the emotion totally out of it, but as things kind of go on, the emotion kind of dims a little, and it's a little easier to work out some outcomes in. Okay. Then when the mediator gets that common ground, gets what they both can agree on, writes it down, and the parties sign it, and away you go. And I honestly, one I was involved in, it was two lawyers had hired a third party. And I was kind of involved with one of the lawyers, and they mediated this thing, and And literally, the mediator just wrote it out on a legal pad, and the lawyer signed it, and that was that. That was as official as it got. They never typed anything up or anything. I kind of shook my head and thought, oh, okay. But it was, a legally binding document. It was signed by the parties and whatnot, and so away they went. Okay, it's informal, so again, it's controlled by the parties. The mediator, does these things. Okay, this looks like a more formal process than how I explained it, and there is, I guess, a bit of a formality to it, but it's also very informal when you're talking to the mediator. You're just having a conversation about how you feel, what your side is. So, mediation can be mandated. Okay, sometimes you'll see courts tell the parties, hey, go mediate that, see if you can get it settled. That could be the case with the wrong roof thing. They're fighting it out, and the judge may just say, before we go to trial about this thing, because really, what do you want to go to court for? Let's maybe bring a mediator in and see if we can find some common ground. So, okay, now I say that mediation is not binding, and the mediator cannot impose a binding solution. The mediator cannot come out and say, hey, I've sided with this person, or hey, you guys are going to split the difference, and that's just that. Okay, no, both parties have to agree to it. Now, after they've agreed to it, they've signed an agreement, then that part can be legally enforced. Okay, that is binding then. Okay. All the following are advantages of arbitration over litigation, except the right to appeal and takes less time is right. It's non-public and it's not as expensive. Okay, but the right to appeal isn't an advantage because you can certainly appeal litigation rights. So you can appeal both, so it's not an advantage of one over the other. Some other, and you could have a combination. You might go through mediation and then go to arbitration, right? Mock trials, a citizen review. You might actually pay a jury. The parties might get together and say, we're having troubles doing this. Let's pay a jury. We'll go through some processes, but rather than go through the courts, system, we'll make it a lot more informal. It might be a wake-up call for the parties, either the plaintiff or the defendant. Okay, mini trial would be similar, but you might this case you might do a judge, maybe a retired judge, and just pay them, right? Judge Judy or Judge Wapner or whatever. Okay, and you might ask them to come in and try to resolve that kind of a dispute. And again, I'm not really aware of those happening in Montana. I haven't read of cases like that, and so I'm not saying that they don't happen, but I just don't see them too often. So I'm going to go ahead, I think, and I know I've got Chapter 6 to do, but I'm going to shut this down, and that way you guys can take a break, and I can too, and we'll do Chapter 6 under a separate recording. So I'll talk to you soon.